rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. This is the time set for oral argument in 1 CV16 0466, Hildenbrandt v. KRASNER et al. Each side is allotted 20 minutes for oral argument. Appellant may reserve a portion of that time for rebuttal, but counsel, if you wish to do that, you'll need to keep track of your time using the podium clock. And out of respect for counsel, I ask those in attendance to please make sure your cell phones are off or on vibrate. Counsel, we have read and conferenced this case this morning. We encourage you to keep that in mind as you present your oral argument today. Also, the proceedings are being recorded and we've posted to YouTube. So before you begin your argument, please state your name and the party you represent. With that, we will start with the appellant. Mr. Harris, go ahead.
Thank you.
Good morning, Your Honor, and may it please the Court. My name is Jeffrey Harris. With me is Bradley Schultz at the counsel table. We represent Phyllis KRASNER and Charles Malika. Ms. KRASNER and Mr. Malika are neighbors in Ballantrae Ridge who have invested years of their lives and hundreds of thousands of dollars investing in their homes in reliance on two restrictive covenants which have been observed for nearly 30 years and have been observed by all 5 owners of the property since they were initially recorded. However, the trial court erroneously granted summary judgment invalidating those restrictive covenants after making a finding of ambiguity where one does not exist. Second, applying an incorrect and explicitly rejected legal standard. And third, failing to consider relevant and unopposed evidence as to the intent of the parties, the purpose for the creation of the deeds, and the circumstances behind their creation. As to the first point, Your Honor, in 1989, the declarant, which is a defined term under the Master CC&Rs of Troon Village. Now, these properties, lots 13 and 14 are owned by the appellants, and lot 8 is owned by Appellee. This was developed by DF Developers, who was the capital D declarant underneath the Master CC&Rs of Troon Village. The Master CC&Rs of Troon Village governed the entire property of Troon Village, of which Ballantrae Ridge is a subdivision. There are also a set of CC&Rs as to Ballantrae Ridge. However, those are subservient to the Master CC&Rs of Troon Village and explicitly state that if they are less restrictive or in derogation of any of the Master CC&Rs, then the provisions of the Master CC&Rs govern. That's important because the Master CC&Rs here gave an unrestricted and absolute right to the declarant to further restrict its own property without the consent of any other owner. DF Developers deeded by a general warranty deed this property of Ballantrae Ridge to an entity called Ballantrae Ridge Limited Incorporated in 1985, together with all rights and privileges appurtenant thereto. Therefore, they became the declarant as the defined term underneath the 1985 and 1989, the 1985 warranty deed and the 1989 restrictive covenant. In doing so, they exercised that unrestricted and absolute right in deeding this property to 6 adjoining landowners, restricting building of any residence upon Lot 8.
Are you suggesting that the six property owners could not have gotten together on their own and decided, turns out we don't really care that much about having open space next to us. All of us agree and we'd like to we paid full price for this. We'd like to get full price and sell it to somebody else, and we're willing to lift that restriction. Could they have done that?
No, Your Honor, and the reason for that is they couldn't give what they didn't have. Initially, in the 1989 deed restriction, that ran with the land because the declarant had the absolute and unrestricted right to further restrict its own property, and any tract declaration which it made underneath that right would run with the CC&Rs as if fully a part of them. Therefore, the 1989 deed restriction, we believe, was used in the exercise of its full and unrestricted power for 2 purposes. One, to restrict this property underneath its unrestricted power, and second, as a tract declaration, though that's not necessary to find it
Was
was
that
one.
done before these lot owners bought their property, or was it done?
Yes, it was, Your Honor. It was done initially when the Ballantrae Ridge Limited Incorporated, the declarant, developed this property. There was nothing existing at the time, and so.
Well, what's the purpose of selling the lot to the 6 property owners if no one can develop anything on it? Why do they need to buy that?
Well, Your Honor, the record's undeveloped in regards to why it was created as a lot, but what we do have is the uncontested evidence below that the intent of the declarant was to ensure that these 6 owners had a view. We can read into that, but we don't need to.
But if that's the point, why sell that at all?
Your Honor, that's a good question, but I think, and I don't have an answer to it because it's not developed on the record. However, that's irrelevant to the analysis here because they did. And since they did, now we have to pick up the pieces of understanding what they originally intended. That intent is underneath Powell v. Washburn. The trial court here unfortunately did not cite Powell v. Washburn and cited laws such as Palermo, Wilson, and Lacer, all of which were decided prior to Powell, in finding that they were going to find an ambiguity in these restricted deeds and construe them against or in favor of the free use of land. So the first argument that we've made is being this ran with the land because it was a part of the CC&Rs. And so I guess to more fully answer your question, the 6 owners could not undo that restriction until there was a change in circumstances or without 75% ownership vote under the CC&Rs. When the declarant owned the property, that 75% vote was not required under the master CC&Rs, and so it had an unrestricted right. But as others owned that property, that 75% vote came into place. So our position.
You're not asking us to declare that there is a deed restriction. All you're asking us is to vacate the granting of summary judgment, correct?
Your Honor, we are asking, in the briefs, we've asked for a vacation of this judgment and to be reversed and sent to the trial court for proceedings consistent with Powell v. Washburn. However, since this court does construe contracts, which restrictive covenants are contracts, you do have the power to rule in favor of KRASNER Malika on the initial 1989 deed restriction as a matter of law that it did run with the land, that the declarant did exercise its full unrestricted authority, and that regardless of what the 1990 deed further restricts or not, there can be no residence built upon the property. Once we get to...
You're saying the CC&Rs have been amended?
They were amended in 1989, and by the language of the CC&Rs, from time to time, this is in the record at index number 80 at paragraph 9, as portions of the property are readied for development, additional declarations as to portions of the property may be recorded restricting the use. It also stated that...
But did the original developer specifically authorize Desert Foothills developers to amend the CC&Rs?
Your Honor, our position is that for Ballantrae Ridge Limited, the rights of DF developers were conveyed to Ballantrae Ridge Limited Incorporated by way of that 1985
the right specifically to amend the CC&Rs as well?
Well, I don't believe an amendment of the CC&Rs were required. It was the unrestricted and absolute right that was reserved by DF developers, which was conveyed in part to Ballantrae Ridge for that section of the property to further restrict the property. Does that answer your question?
I think so.
Okay. Your Honor, second of all, even if there is an ambiguity in the construction of these deeds, it can't be construed with an inapplicable standard. Palermo, Lacer, and Wilson can all be distinguished. Palermo was a 1962 Supreme Court of Arizona case, and it specifically dealt with an instance where there was not a common developer of the property. Further, it stated that it only applied as to general. It stated in footnote 1, which has been incited in Apley's brief, that where the cases are in conflict, except as general principles are recognized and declared, those recognized principles were put into place in Powell v. Washburn. Powell v. Washburn in 2006 was an en banc Supreme Court case, which, of course, Your Honors are aware of, which has been briefed, where the intent-based approach of the restatement third of property servitudes was adopted for all restrictive covenants, whether CC&Rs or not. And so, regardless of whether this court finds as a matter of law the 1989 deed restriction ran with the land as part of the CC&Rs, it was intended to do so, and so ran with the land.
What's the evidence that it was intended to do so?
The evidence, first of all, is the language in the deed itself, and second, the affidavit testimony of the grantees to the deed. First, the language itself defined the lot.
But that doesn't say anything about that first deed goes to the purchaser's intent. It doesn't go to the developer's intent at that point. And if their intent was simply, at this point, we want to have open space next to us, we may decide down the road that we don't want to have, that we don't care that much about it. It may be more valuable to us to sell the lot. I have a hard time getting there on that first deed.
Well, as to the first deed, Ballantrae Ridge stepped into the shoes of the original developer. The developer hadn't developed anything prior to that conveyance in 1985 and them stepping in the shoes to develop this property. So first of all, the intent was to protect in perpetuity the rights of the 6 owners to a view of Troon Country Club, to effectuate the purpose of recital E in the master CC&Rs is to keep open spaces. And when Powell v. Washburn was decided, one of the important points that it repeatedly hit upon was that the intent of the parties is the cardinal principle, which does not need to be construed merely from the language of the documents. The restatement third specifically states that there aren't particular verbal formulas required to create something that runs with the land. In section 2.2 in comment D, it states historically those types of to the heirs, successors, and assigns were used. However, the great...
And the term runs with the land has been used in some deeds.
Correct. It has been, and Your Honor, it's not dispositive here because, going back to your question, whether or not that was in the deeds, we have to look to the circumstances and the language that was used, that it was restricted. The first illustration, illustration 19, to the restatements in section 2.2 actually point to an exactly on point situation where there was a deed restriction because of there being a restriction for a 2-story development on the property. Even though runs with the land and to heirs, successors, and assigns was not included in that, the restatement, which was adopted, states the nature and object of the covenant justify the conclusion the burden was intended to run with Whiteacre and the benefit was intended. Restrictive covenants can be express or they can be implied. That's the restatement approach. Here, of course, it would have been better to have stated that this runs with the land, but everything else points to the fact that it was intended to do so, and there's no contrary evidence to the fact that it was intended to do so. When the 6 owners received this property, Luann Tuitt and Gene Hicks have provided sworn declarations which have not been opposed that it was the intent of the declarant to keep this lot available, to not build upon it. Now, initially, there was a country club membership that could be purchased through the ownership of land. That changed in 2008. However, that doesn't create a changed circumstances underneath the restatement approach of Powell, because the intent and the benefit that these appellants are clothed with is specifically directed to what is built and what's not built on Lot 8, and they have relied and detrimentally relied upon this restrictive covenant. So until the changed circumstances are such there is no residence in this development, that will need to stand. Your Honor, going back to the language of Powell v. Washburn, it specifically states that a servitude should be interpreted to give effect to the intention of the parties ascertained from the language used in the instrument or the circumstances surrounding creation of the servitude and to carry out the purpose for which it was created. There would not have been a purpose in creating a 1-year or 5-year or 20-year limitation. The overall purpose of the master CC&Rs was to develop this as a first-class development. For whatever reason that's not on the record, Lot 8 was decided to be platted. However, after it was platted and it was conveyed, the developer and the declarant themselves decided that it should be restricted against building of a residence in any other type. In 1990, this was further restricted when the 6 owners conveyed it to Lanny Lahr and conveyed it not only to be restricted against building of a residence, but also stated it's restricted against the building of any structure and that, quote, it is to remain vacant, unquote. So the best that we have in terms of the intent here is that it was stated to be restricted twice in the deeds as well as it was to remain vacant, and that's apart from the fact it ran as fully a part of the CC&Rs. I'd like to reserve the remaining time for rebuttal. Thank you.
Thank you, counsel. Mr. Combs.
Good morning. My name is Chris Combs, and we represent the appellees Hildenbrandt. I just want to make a couple quick comments about the opening argument of the appellants. The first deed from the developer to the 6 owners clearly showed the intent of the developer. The developer, that whole project was represented by Snell and Wilmer, relatively bright lawyers theoretically, and they did all the documentation. They easily could have put in the standard in perpetuity, running with the land, successors and assigns. They did not. And the reason they didn't is that lot had no value to them if it was barren. It had value as a potential model home. It had value for HOA fees. So if you look at the original intent in 1989, which I don't think at this point is even admissible evidence, but if you did look at it, it would show, I think, that the developer did not intend that this deed restriction run with the land. I think just a little brief history of Lot 8 would really be helpful. In the 1989 deed, the conveyance of Lot 8 conveyed 3 benefits to the 6 owners. The one benefit was the view was protected. The other benefit was the vacant space next to them. And the third benefit was a conditional benefit, namely conditioned on the golf course membership, lot ownership being a requirement of being a golf course member at Troon Country Club.
How was that a benefit to those?
Pardon me?
How was that a benefit to the other 6 owners if they already had lots? Why would that be part of the benefit of selling that property?
If you notice, and I'll get to that. Well, I can get to that now. In the 1990 deed, the 6 owners got $40,000 for that conditional benefit.
And do you know how much they paid? Was the original purchase price different than the purchase price for their other 6 lots?
I don't think so. We couldn't find an affidavit of value, Your Honor, which would show the value of Lot 8. But I assume it was a developer inducement to buy these lots, and as long as you owned that lot, then you had the views. But if you sold the lot, then it would go back on the market, and there could be a model home or HOA dues being paid to the developer. Does that answer your question?
Well, let's focus on the second. Go ahead with what you're saying. I'd like you to focus on the second transfer from the 6 owners to someone else with a deed that says the lot shall remain vacant. It's not to be developed.
Well, part of my argument on the first is the second. So let me. Basically, the 3 benefits, but there's the 3 burdens, and there's not been much discussion about the 3 burdens. 1 is the HOA fees, 2 are the property taxes, and 3 is the obligation to maintain. In other words, if somebody throws trash on there, it would be the obligation of the owners of Lot 8 to take the trash. If the weeds start growing up, become a fire hazard, it would be the obligation of the Lot 8 owners to take it off. And to show you the essence of our position, hypothetically, okay, the 1989 deed transferred Lot 8 to the 6 owners. 2 months later, the Troon Golf membership requirement of ownership, lot ownership, is removed. That lot is worthless. They wouldn't get, the 6 owners wouldn't get 40 grand to sell it to anybody else. It couldn't be sold to anybody else. They would have what they wanted, which was the view, the blah, 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 the open space. They'd have exactly what they wanted, but they'd have the burdens also of the HOA dues and the property taxes, blah, blah, blah. And that would be a correct result. That's what should have happened.
Would they have some sort of, I'm sorry, I'm not completely following. They have the benefit of they've got vacant space next to them. They have to pay more fees because they decided they want bigger lots, essentially.
No, they own their individual lots, and the 6 of them, like 19%, 18%, the 6 of them own Lot 8 together.
But essentially, it has the effect of increasing the size of their lots, and they're paying a homeowners association fee for that. I'm not sure I see that as an unfair burden on.
No, I'm not saying it's an unfair burden, but those were the burdens. If the lot they would have those burdens forever, because they couldn't sell the lot. The lot's worthless. You can't build on it, and you have all these obligations or burdens. If 2 months later, hypothetically, the rules had changed. Let's go to 1990 deed from the 6 owners to the layers. Still the Troon Country Club membership, and they sold it. They flipped this basically within a year. When the 6 owners, they flipped it within a year to the Lars. They picked up 40 grand in cash for the lot from the Lars.
You're saying they flipped it. Did they sell it for more than what they paid for it, or did they sell it for less?
No, they sold it for the same, Your Honor, $40,000. But I'm saying they didn't hold on to it very long. Within a year, they closed on the sale to the Lars.
And they sold it with an express condition that there wouldn't be any construction on it, that it would remain vacant.
Well, they had the existing one that the developers put on the property, and they had
they put it in their deed that they transferred. When the 6 of them sold it, they put it in their deed.
They put the one that, and they added a more explanatory second restriction, but the same restriction in essence.
So if they do that, and the person just turns around 1 month later and sells it to someone without putting that wording in the deed, does that mean the 6 owners can't enforce the provision in the deed?
Yes, Your Honor, they cannot. There's absolutely nothing in there. And Judge Bustamante specifically made as one of her findings that the covenants were personal, and that was the essence of her findings. They were personal. There was nothing in there. There was no successors in the signs, no in perpetuity, no running with the land, nothing whatsoever that indicated that those restrictions we have with the land.
But when it says shall remain vacant, what does that mean to? And do we interpret this as an average person would looking at the deed, or do we interpret it through the eyes of someone who's seen language about runs with the land or successors in interest? Seems to me looking at a deed that says this shall remain vacant, that means I'm selling it to you on the condition that you're not going to build on it, and that it shall remain vacant. You can't turn around and sell it the next day and have someone else build on it. Isn't that a pretty reasonable interpretation? If we're looking at it through the eyes of a reasonable person, couldn't someone come to that conclusion?
Well, a reasonable person, a typical buyer, does not usually even see the predecessor deed. All they get is the title report saying, if you become the buyer, these are the exceptions on your deed.
But isn't that part of a buyer goes through a title company? It has to look, and there's a previous deed that says there is a restriction on building on this land. Don't reasonable people understand that whatever deeds have been recorded and contain that restriction? Aren't we looking to that language in addition to all the deeds on the property?
Well, when you say, well, in our case, in the Hildebrandt's case, when they bought the property in 2005, there was no mention of any of these restrictions. When the Porters bought the property from Mr. Delairs,
but they understood, and that's why they presumably seek recovery from the title company, because they understand that there was a deed in place that the title company apparently didn't catch. Is that accurate?
Well, yeah, the title company made a mistake, and we got reimbursement for our purchase price, but at this point, we're liable forever for the HOA fees, the property taxes, and maintenance of the lot with absolutely no benefit whatsoever.
But do we know that there's absolutely no benefit to the lot? How do we know that there's zero benefit to the lot?
From the deed restriction.
But it initially was sold. There was evidence it was sold as a way of getting membership in the country club. Is it clear that there is a discounted membership for people who own property? Why is that something that we can say as a matter of law there's zero benefit to owning that piece of property?
Well, in the case of the Hildebrands, there's definitely zero benefit. There's a detrimental benefit. They have to write checks every month for a lot that, if the deed restrictions are enforceable and Judge Bustamante is overruled, said you can't even place anything, not only just construct, you can't even place anything on the property, probably not even a tent. I mean, there's a major stretch to think that this lot has some value when you have to write checks every month for property taxes, HOA fees, and maintain the property, and you get absolutely no benefit from it.
But isn't that an argument about changed circumstances as opposed to this language wasn't clear to anybody who looked at the deed that there's a restriction on building?
Well, again, I think it's very clear there was no statement saying it ran with the land. It's just, this is the restriction. You can have personal restrictions.
If you bought that piece of property, and let's say nothing had changed with the golf course membership, you bought that piece of property and it said there's a restriction on building on this land, would it ever cross your mind to think that it's okay, that didn't say I can just assign this to my son and he can build on the land? Would that have occurred to you with that language in there? There's a restriction on building, it shall remain vacant.
Yeah, if I personally was buying the lot and I saw that restriction, I would not close on it without it having been cleaned up by the title company. If the title company insures over it, and they might have, if it was a $500,000 lot, they might have insured over it and defended us on this situation. But they on a $50,000 lot, I think they just said, well, way back in 1990 we missed it, even though two subsequent deeds had no mention of it, and we'll just cut a check for 50 grand and move on. But so I don't think that it's as simple to say that because it's in there, you automatically assume it runs with the land. The presumption is it doesn't run with the land. You have to have language in there that it runs with the land. There's absolutely no one word in there that indicates it runs with the land. And that's what Judge Bustamante found. She said there were personal restrictions.
Didn't she suggest that we're going to apply an approach that seeks the best use of the land as opposed to an approach that looks to the intent of the parties?
Well, I mean, if you know, her minute order on 5.6 specifically says what? She says in the 1989 and 1990 covenants are personal and nothing to indicate that the covenant to run with the land. And the Hildebrands bought Lot 8 with the standards subject to restrictions that apply to almost every deed. So, and she went on and talked about ambiguity and intent, but it was, I think, I've been before Judge Bustamante several times. She's a very nice lady. I think she just threw a bone out there. If it was ambiguous, then this is what I would rule. But I mean, her whole argument is it wasn't ambiguous.
If we were to reverse Judge Bustamante, it would go back for a trial, correct?
Absolutely not. I mean, Powell versus Washburn was not a trial. There were no depositions or anything. There was a question of law based on the four corners of the document.
But under assuming we look to the intent of the parties, you would have a chance to to explain the intent of the parties that you may disagree with what the neighbors are asserting.
Well, the neighbors, these are the appellants are the two remaining neighbors. They didn't buy, I think, 2001 and 2013 is when they bought that. 1989 is almost 30 years ago. Most of the principals involved are probably deceased by now. It's more or less a golf course retirement community.
But they have successors in interest. They have people who bought it who presumably know that there's a vacant lot. If you sell the lot to someone, if you sell your house and it's next to a park or a vacant lot, and there's a restriction that says this will remain a park or a national forest forever, or whatever, isn't that a sales feature? And the person who's buying it presumably relies on that, would they not?
Well, they could rely on it, and it may be a misrepresentation by the sales agent.
And is there some misrepresentation to say that there's a deed on that lot that says it's restricted from building any buildings and it shall remain vacant? Is that a misrepresentation?
Absolutely not. But under the law, there's no evidence that was that. Like I said, there's standard language, just like the subject to language, subject to easement, other matters of record, et cetera, in every deed. There's standard language which the original declarant could have put in there, and and didn't for obvious reasons. There was no interest of the declarant to have it remain vacant. And the 1990 deed could have had it in there.
Declarant, you're saying the original developer. There was.
Well,
no
I'm sorry.
interest.
Yeah, I'm sorry.
And maybe we might be persuaded that that Valentine Ridge didn't have the authority to amend the CC&Rs, and maybe the declarant, the original developer, didn't have any particular interest in that. But that goes to the 1989 deed. But the second deed, it seems pretty clear that the people who executed that deed had an interest in keeping the property vacant,
Okay.
undeveloped.
Then I have three comments. One, why'd they sell it? If it's so important, and Ms. Krasner testified there's somewhere between $100,000 and $1 million loss in value. She couldn't put a number on it. If it's so important to the, why didn't they put something in there that said it could not be sold? Part of the deed, you can't even sell the lot 8.
You could sell it with it had value as a golf course membership at that point.
At that point, yes. But also, they could have put in a paragraph on running with the land, in perpetuity, whatever, a full paragraph in there, and they didn't. They could have put in a requirement that there be approval of the original lot owners, or at least notice. I mean, they put nothing in there. These are the deed restrictions, period. And the subsequent owner, the Lairs, they just removed them completely. So they obviously didn't think they applied, or I don't know what they thought at the time.
Would your clients be able to argue that the circumstances have changed so that the deed restrictions shouldn't apply?
Well, that's our second argument, Your Honor, which I think is equally strong. There's been a major change in circumstances, because of the proliferation of golf courses in the North Scottsdale area, and because of declining interest in golf in general. In 2008, they wanted to bring more members in.
Did the Superior Court rule on that basis?
Pardon me?
Did the Superior Court rule on that basis?
On what basis?
Changed circumstances?
Yes, it's in there on page 5 of her ruling.
And said that because of change, independent of this runs with the land, there are changed circumstances that warrant.
Well, she has a paragraph on the changed circumstances, including also some of the other build-outs there. There's view restrictions anyhow, so there's been changed circumstances.
Then is that one basis for granting summary judgment then?
I'm sorry, sir?
Is that one basis for granting summary judgment?
Changed circumstances? Yes, I think definitely.
Well, but my point is, did she say that in her ruling? That was one basis for granting the motion?
I don't have a ruling in front of me, but she has on page 5, there's a paragraph that specifically says changed circumstances.
It seemed to me my recollection is it just went to what's kind of the best use of this property now. There are changed circumstances, but I don't know that there was it went into the analysis of it runs with the land. I don't recall, but we'll look at that. Go ahead, sorry.
Yeah, the changed circumstances are so patent here, where a lot has a value of $40,000 in 1989 and is totally worthless now. In fact, less than worthless because you have to write checks every month.
But you agree that's an argument that's independent of whether it runs with the land.
Correct.
Because you would, even if they had put in the deed, this runs with the land, successors are bound, you would still have an argument. There are changed circumstances we need to try to, we at the time it was sold, we didn't realize the country club was going to remove that as a requirement for membership, so we've got to do something. But that's independent of, does this run with the land?
Correct, Your Honor. And what we have here in my remaining time, we have Mrs. Hildebrand, who's in her late 70s. She's the classic, widow case, and she can't do anything with the land. She has to write checks every month for the HOA fees. They did nothing wrong. They went to a title company. They bought the land. They wanted to build on it, build a home. Mr. Hildebrand, before his stroke, he didn't play golf, and they had no interest in golf membership. And now, Mrs. Hildebrand, the rest of her life, if Judge Bassamani's ruling is reversed, will have to pay property taxes, HOA fees, and maintain that lot. And then when she passes, her children will have to. And then when their children, it goes on and on. I mean, I think.
Not precluded, though, from raising an argument about changed circumstances.
Oh, no, absolutely not.
Okay.
I think there are two independent bases to support Judge Bassamani's ruling.
And the settlement with the title company, will not compensate her for
What? It comes if she paid 50 grand. She and her husband paid 50 grand. They cut a check for 50 grand. That was back in 2005. And so since then, that's 12 years. She's paid all the HOA fees and the property taxes and everything. And it's going to go on forever if Judge Bassamani's ruling is reversed.
well, is that accurate to say? Because all that, if we reverse the summary judgment, it doesn't mean that your client loses. It just means it goes back to the trial court, correct?
Absolutely. I don't know what the trial court would hear. I mean, either there's changed circumstances or not. That's not in dispute.
But we would simply be vacating a grant of summary judgment.
Well, I mean, obviously, it's up to the court, and whatever the ruling is, we'll have to review it and work around it. But I just think it's totally unfair that when the Hildebrands did absolutely nothing wrong, that at this point they're stuck forever with paying all these obligations. Thank you much.
Thank you, Mr. Combs. Counsel?
Thank
So
you.
can you talk about change of circumstances?
Yes, Your Honor. First of all, changed circumstances was not a basis on which summary judgment was granted. Changed circumstances was discussed, as Mr. Combs stated, on page 5, number 6, as a conclusion of law. However, there's only 3 specific paragraphs that go to the rulings. Changed circumstances is not mentioned at all. It was not a basis for the granting of summary judgment.
If we were to reverse, would that be a live issue then?
Your Honor, potentially. I don't think it should be here. And the reason for that is the changed circumstances don't go to the benefit of the surrounding lot owners. The doctrine of changed circumstances, as we understand it, is from the case of Lacer. Lacer talked about whether or not a courthouse could be built on property, and the person who sued there was an heir of the original grantor. There was a new courthouse that was developed, and they said because of a change in circumstances, this person did not have standing to sue. That did not deal with changed circumstances here. Ms. KRASNER and Mr. Malika have no changed circumstances that the intent for which this purpose, this restrictive deed was created, has changed at all. It would still.
I thought that other homes have been built and the view has been obstructed more than it was originally.
Your Honor, we concede that there may have been some building in the meantime which has obstructed more of their view than was originally. However, putting a home directly on Lot 8 would entirely rid them of all of the benefits with which they are clothed underneath these 2 deed restrictions, and there hasn't been a change in circumstances there. If this became commercially zoned and was now a business of some sort, that would be a change in circumstances, not whether or not there's a golf membership tied to it. So first of all, this court should reverse the trial court's ruling because change in circumstances was not even dealt with there, and it cannot be affirmed for that reason alone. Second of all, there was a finding by the court that this was ambiguous. And we've argued why we believe it was not. But even if this was ambiguous, Ms. KRASNER and Mr. Malika have the right to a jury trial to decide what the intent was of the parties. In Chopin v. Chopin, which was from the Court of Appeals in 2010, it states where contract language is susceptible to more than one interpretation, the matter should be submitted to the jury. And from Pasco v. Talco, it states we recognize if a contract is ambiguous, determining what the parties intended is a question of fact for the jury. On page 6 of the ruling, the trial court stated the court will resolve the ambiguity and existence of the restrictive covenant against the restriction and in favor of the free use and enjoyment of the property. The reason that is incorrect is for two main points. First of all, they construed an ambiguity without extrinsic evidence and unopposed evidence. There's actually nothing opposed to the declarations of the grantors and grantees to the 1990 deed and the grantees to the 1994 deed. Second of all,
ambiguity is simply the absence of language that could have been put in.
I'm sorry, what was that?
The ambiguity is, in theory, the absence of language that could have been used.
I believe
runs
so.
with the land.
That's my understanding of the trial court's ruling. I can't speak for her, but that's my understanding that of what was or was not stated. And as we've stated, it forms a part of the CC&Rs, and it says it was to remain vacant. Also, under Powell, we have to consider the intent and the purpose. As stated, Gene Hicks, Luann Tuitt, Lanny Lahr have all put forth testimony evidence which must be considered by the trial court. The trial court did not even deal with or recognize these in her ruling. It wasn't mentioned at all. Who actually wrote the 1989 deed restriction wasn't mentioned at finding of fact number 1. There are issues here which, if judgment is not granted, must go to a trier of fact specifically to determine what was the intent of the parties. For these reasons, Your Honor, we request that judgment be entered, finding that Lot 8 is restricted against building or construction of any type. Second, in the alternative, that this be reversed to the trial court for proceedings consistent with Powell v. Washburn and not with previous principles which have been explicitly rejected in 2006. And third, in any event, that the award of attorney's fees and costs be vacated. Thank you.
Thank you, counsel. I want to thank you both for your briefs and the presentation you presented here today. We will take the matter under advisement. We will issue a ruling in due course. We now stand adjourned. Thank you.